humbly seeks permission to address the bench collectively as Lordship and Ladyship. This is counsel appearing on behalf of the petitioner in the Honorable Supreme Court of India in the writ petition number of 2023 under the Article 32. Issue 1 is collectively submitted that the amendment pertaining to the appointment of Chief Minister affects the constitutional provision and the position of the Governor. The Council humbly requests the
petition.
It is under the public interest litigation, my Lordship.
Association can be filed writ petition.
Indeed, my Lordship, it has.
What you are aggrieved about the, how you are aggrieved?
The petitioner is being aggrieved on the statement with a consultation of the election commissioner, my Lordship. And there have been particular alliances which was made only for the favor of winning the election, upcoming election, and there have been 7 election commissioner transferred and changed in the span of 10 years, my Lordship.
On the ground of election commissioner being brought under the purview of consultation.
Indeed, my Lordship.
So that's the sole crux of your argument.
Not only that, my Lordship, instead the power of the Governor, which is being extraordinarily discretionary violated, my Lordship.
Now I put it in a different way.
Indeed, my Lordship.
Are you challenging the whole amended class?
Indeed,
or is it
my
only to the point of no, the Chief Election Commissioner being brought into the purview of consultation?
The Council would be contending on the clause of wherein no party won the majority Governor shall in consultation with the election of Commissioner call upon the party or pre-poll alliance, and also that the article shall have an overriding effect over any law, my Lordship.
Okay. So,
to be more specific, what my learned friend has been putting to you.
Indeed, my Lordship.
To be more specific, Election Commission is only with regard to the conduct of the election.
Indeed, my Lordship.
Election
Conducting of the
Commission is
election.
only with regard to the conduct of the election.
Indeed, my Lordship.
Their role comes to an end there.
Indeed, my Lordship. That's what here the Council is contending.
Whether the power of the Governor to call, in view of the amendment, to call upon a commission whose purpose is only to conduct the election
Indeed, my Lordship.
is necessary or not.
It is not necessary, my Lordship. That's what the Council is contending in here as a petition, my Lordship, being violated of the entire preamble of the Constitution in reference to the case 7 and the Bharati case, my Lordship.
So you want to say the power of the Election Commission comes to an end
Once
only
the
on
election is
conduct of
conducted,
election, and they have no role to play further.
The role is already played by the executive.
If you want to say that the role played in calling upon the election commission to express its views to the governor in view of the exigencies that may arise,
Indian Lordship.
there may be a point that the electoral mandate is being overthrown.
Indeed, my Lordship.
Otherwise, how we are aggrieved by that?
My Lordship, the Council would elaborate with the statement is that the people elect the particular chief ministership for their ruling government, my Lordship. But whereas the chief election commissioner is not elected by the people or the respected state citizens, my Lordship, they are indirectly.
I hope you understand between the word consultation and concurrence.
Indeed, my Lordship.
Now kindly remember the class, amended class,
Indeed, my Lordship.
isn't it?
Indeed,
So
my
in
Lordship.
case where there is a majority, where there is no majority,
Indeed, my Lordship.
now wherein no, the elected members can identify a person to be the leader who will be called as the chief minister instead of no, wherein he will be called. In case such contingencies are there or not there, kindly remember there is a practice of horse trading.
Indeed, my
It has
Lordship.
been India had witnessed it so many times.
Indeed,
That too
my
in the state parameters, it is going in a very maximized way. With a view, the government has come with this amendment.
Indeed, my
How
Lordship.
do you attribute arbitrariness? How do you attribute malafidness in this amendment?
The biggest issue in here is that, my Lordship, the malafide intention is that, if you refer to the paragraph 4 of the Constitution, and it is clearly stated that these kind of election commissioner are being elected for the purpose of winning the election commission. And here the council would inhibit an illustration procedure, my Lordship, whereby the amendment clearly states that if the chief minister can call upon any party who can, if there is no majority, they call upon any party or party of alliance, my Lordship, which clearly the council would illustrate in here is that if the state possessing 100 seats, my Lordship, and if the 100 seats have been 3 party to participate in the election, and the seats such as X, Y,
The point of issue is very simple.
if the least winning
Now,
can,
supposing, assumedly,
indeed, my Lordship.
if the class of consultation with the election commissioner is not there, or acceptable,
Indeed, no, my Lordship, the discretionary power of the governor is being questioned here in the new amendment, my Lordship.
it's not a discretionary power. Please remember, he has been following the mandate which is given under the constitution.
My Lordship, the council,
Now, it's a constitutional amendment. Kindly remember,
indeed, my
the
Lordship.
governor happens to occupy a position of head of the state in
Indeed, my
Jor,
Lordship. Indeed, my Lordship.
isn't it? No, he has to perform as per the mandate which is given under the constitution.
Indeed, my Lordship.
So when he is given a direction to call the person who is enjoying the majority as per the first class,
Indeed, my
unamended
Lordship.
class, naturally
Indeed,
he is doing it up.
Indeed, my
How do
Lordship.
you find fault with the function of the
The
governor?
matter is that the president is appointed by the constitution only to appoint a chief minister to take an oath and affirmation, my Lordship. And appoint a chief minister, my Lordship.
Now he is the, please remember, he is the head of the state in law.
Indeed, he's a titular position, my Lordship.
Now he is having an obligation to abide by the words of the constitution,
Indeed, my Lordship.
isn't it?
Indeed, my Lordship.
So you are not agreed with regard to the existing class in the first parameter,
Indeed, my Lordship.
isn't it? So you are agreed only with the exigencies where there is no majority,
Indeed, my Lordship.
isn't it? You are pointing your argument on the question of no, how is that he is going to consult the chief election commissioner?
Indeed, my Lordship. Here the council would illustrate in a certain way that the mandate power of the governor is to it's not to elect a person, it's a duty of the citizens to elect a person for the particular election period to win if they get the majority, they can definitely be the chief minister. But in here the new amendment has possessed the statement that the governor can inhibit the power of choosing the chief minister who comes up with an alliance, even if he is least one in majority, my Lordship. That's the danger thing, where it inhibit and where it does not inhibit any democratical principles, and it clearly
It's
leads to
only
dictatorship, my
it's
Lordship.
only assumption.
It's not an assumption, my Lordship. There is a clear statement in paragraph 7 of the proposition which clearly states the similar thing, where the appointment of the chief election commissioner only to win
You are-
future elections, my Lordship.
You are pointing your argument more on the position of the chief election commissioner,
Indeed, my Lordship. Indeed.
isn't it?
Indeed, my Lordship.
So leave away, supposing instead of chief election commissioner,
Indeed,
if
my
it has been put somebody else, you will be agreeing?
It's subject matter to discussion, my Lordship. It's a subject matter to the judicial immunity to decide upon the particular statement, my
So
Lordship.
you know we are following a system called as Westminster system.
My Lordship? Pardon, my Lordship?
Westminster system,
Indeed, my Lordship.
what is it?
Which is a British system where we have a separation of power with state and union, my lordship.
It's not mere separation of powers.
The federal structure, my lordship. The federal structure, the council would be clear.
Please continue.
Indian, my lordship, Indian, my lordship. The council would further state that in the case of Rameshwar Prasad versus Union of India, in the citation of in the year 2006 SCC 1, which clearly states that thus the governor, despite being a titular head like the president, still enjoys the many wide powers in the state, and such powers cannot be exploited with reference such as election commissioner, my lordship. And here the council would further state that in the case of K7 and the Bharati case, it was clearly stated that the connected with if there is a situation where the interference of the election commissioner would without any bylaws followed below, and the existing procedure affects the integrity of the appointment of chief minister, and which the council here interpret with the case of Global Mercantile Private Limited, which is Indo-Unique Flame, which clearly states that it was said that it is directly connected with local politics. Here the council would humbly refer to the proposition 4 paragraph, which clearly states there is a local politics. Indeed, my lordship.
Striking the very basic structure of the constitution.
Because it hurts the council would refer to the because it endangers the situation of the democracy, rule of law, and the free and fair election followed with the triangular prism, lordship, where even the separation of powers, which is in the violation of Article 50, my lordship.
I don't know how this is infringing upon the separation of powers.
My lordship, Article 50 of the Constitution of India clearly states that the council would. The council here humbly argues that the kind of separation power what we inhabit is that the executive, the governor having just the executive power is which is insisted in the governor cannot be exploited with the interference with the election commissioner, my lordship. That's the point here the council would be substantiate.
No, it's an art. Remember, it has not been implemented.
Indeed, my lordship.
Isn't it? It's only an alternative mechanism in case of exigency, where the electorates are not giving an absolute majority to any party.
Indeed, my lordship.
Isn't it? With a view to avoid subsequent elections, with a view to avoid horse trading,
Indeed, my
all malpractices which are there connected with the elections.
Indeed,
No, they have just suggested, they have not done it on their own self.
Indeed,
They have done it on the basis of a recommendation given by a former Supreme Court of India.
Indeed, my lordship.
How do you attribute arbitrariness and infringement of the independency?
The matter is that the proposition has stated that it clearly there is the election commissioner have been changed by the coalition party whom the rule of party political
Yes,
present in
please continue.
Indeed, my lordship. Here the council would further humbly submit that the election commissioner does not fulfill any of the criteria and also the feature of the democracy, being independent directing of the election ambit alone, and the governor explicitly stated the governor is appointed by the president, serves at his own discretionary power without violating the democratic principle, my lordship. And here the council would humbly directs the bench to refer to the page number 17 of the memorial of the petitioner, which clearly states that in the case of Kito Holihan and Mrs. Jalisto, which clearly state that without upholding its validity, the Supreme Court observed that the objective of the law is to curb the evil of the political defections and motivated by the lure or office of the other similar considerations which endanger the foundation of our democracy, my lordship. This is an absolute interpretation by the petitioner, which clearly.
The case which you are referring to may not be helping you.
Indeed, my lordship, the council would further substantiate with an argument where here the basic structure is that basic contention of the petitioner is that to just when the office of the election
With a solid point, wherein you are attributing arbitrariness or malafide in the bringing of an amendment into the constitution.
Indeed, my lordship, the malafide intention is to win the future election, my lordship, which is where the election commissioner has been in this committee for the consultation by the appointment of the chief minister, my lordship.
The facts doesn't disclose. The government which is there, the center has its own emboldenment in the other states.
Indeed, my
No,
lordship.
this is a design which has been there in the state machinery.
Indeed, my lordship.
How do you assume that they are interested in coming to power again? That too in the state also.
Indeed, my lordship, the council would humbly, there is a bench to refer to the paragraph 7 of the page 3 of the proposition, where there is a coalition of the government, same for the
That
past.
speaks about how instead of a single party coming to the power, coalition has intervened in India, not only in center and also in state.
Indeed, my
That's a
lordship.
different design.
Indeed, my lordship. The council would further argue that thus it is is humbly concluded that the modified amendments affects the constitutional validity and the position of the governor, and it is also ultra wise for the election commissioner to hold such a positional, which is executive supreme position, affecting the sovereign position of the preamble constitution, my lordship. If the bench is satisfied, if there is no questions, the council would humbly move on to this issue 2. Issue 2 is whether the amendment pertaining to Chief Election Commissioner transgresses the constitutional limitation principles, my lordship. It is humbly submitted that the 106th Amendment of the Constitution violates the basic structure of this Indian Constitution, my lordship. It is humbly submitted that when the amendment is made, it has to be from without any repugnancy, and it does not possess any inconsistency, my lordship. But whereas it is stated under case law of Shamrao, which clearly states that there should not be any inconsistency.
How do you say that there is inconsistency?
My lordship, it has clearly stated in the proposition where the amendment, when it is made, it has clearly stated that the article shall have overriding effect over any law prevailing pertaining to Chief Election Commissioner, and any law to the extension of inconsistency shall be inoperative.
That is the purpose of amendment.
That's the purpose of the amendment.
That is why the amendment is brought, so that it will not have an effect, or it cannot be. So the effect of amendment should be given effect to.
Indeed, my lordship. That's why there is here we uphold the jurisdiction for the similar court, my lordship. When this amendment is getting asset from even before the basic local standing for the case is that this amendment should not have this kind of clause. That's why we have the case over in arguing inside the honorable court. But here in the situation, even it appears to be inconsistency shall be inoperative. The subject clause.
No, you should point out where inconsistency with which provision.
My lordship. In the provision of Article 324, clause 2, my lordship. In the page number 4 of the proposition, my lordship.
Now, please read the amended class.
Amended
Class alone.
The selection committee will consist of the Chief Justice of India or a Supreme Court judge, Chief Election Commissioner in office, Prime Minister, and a leader of opposition in both the houses, my lordship.
Okay. What was the position prior to incorporation of this amendment?
There was a. The council would refer to the barrack, my lordship.
No, it means the remaining classes which are there quoted in the problem will be there.
My lordship,
The
pardon,
remaining
my lordship.
provisos.
My lordship.
The remaining provisions are there intact.
Indeed, my lordship.
Isn't it? So the new addition which has come by way of amendment is that, so instead of the president appointing an election commissioner, they have brought in between a committee. Go for scrutiny of the people who need to be appointed as election commissioner.
Indeed, my lordship.
Isn't it? No, this is something which is giving a value to already existing system.
Indeed,
Instead of the Prime Minister nomenclating somebody, identifying somebody to be the election commissioner. Isn't it? Now we have a mechanism wherein all the members who are there in the democratic setup, they have been empaneled and they just scrutinize the members and then make a recommendation. What's harm in it?
The matter is in the council.
This is not a fair procedure. Instead of a single person
However,
and
it can
then
be a fair procedure, my lordship. The matter the council would humbly substantiate with the argument is that the council humbly requests the bench to refer to the page number 20 of the memorial of the petition, my lordship, where the council would inhabit with an argument where even in the case of Anup case.
now kindly remember you are relying of the case.
No,
must
my lordship.
substantiate the point you are raising.
Indeed, my lordship. The
Can you
council
remember?
indeed.
So we have been having a practice where the Prime Minister will be identifying somebody to be the election commissioner and the President will be appointing him. This practice has been there for nearly 76 years.
Indeed, my lordship.
You are not agreed. You are not agreed till this moment.
Until the amendment
So
was
when
made, my
someone
lordship.
has been appointed as election commissioner, but all of a sudden, when they brought a scheme for the purpose of identifying somebody, you are saying this is counter to the constitutional ideals.
Indeed, my
How
lordship.
fair is it?
Indeed, my lordship, the council in here strongly substantiate is that before we have an. My lordship, can I continue?
Yes, please.
Indeed, my lordship. So the matter is that when we have a kind of situation in reference, first we have a member from the Prime Minister and the Chief Justice of the Court of Supreme Court and or the Supreme Court judge, and we have a leader of opposition of both the parties, my lordship. But whereas if the kind of Chief Election Commission present in office for this selection committee, absolutely.
So your thrust of challenging the amendment is only on the presence of the electoral, chief election
Indeed,
commissioner.
my lordship.
So not other things.
Indeed, my lordship.
1 minute. Now please read the previous class, unamended class, which is there in, I think, 324 class 2. Read the line, read the paragraph.
The election commission shall consist of the chief election commissioner and such number of other election commissioner, if any, as the president may from time to time fix an appointment of the chief election commissioner, and other election commissioners shall subject to the provision of any
Okay,
law.
what is the imprint of it?
He is being appointed by the president.
Now please remember, so the very provision which has been incorporated based on the constitutional debate
Indeed, my lordship.
and which has been in operation for nearly 76 years.
Indeed, my lordship.
Now insist a duty on the part of the governing body
Indeed, my lordship.
to bring in a class, to bring in a law,
Indeed, my lordship.
so that the identity of the election commission could be done.
Indeed, my lordship.
So you are not aggrieved.
My lordship, the materialistic substantial argument is that the election commissioner himself is being having an unjust fair of means
So
to
you don't have any grievance supposing the election commissioner is deleted from this election committee.
we have
Can you put that way?
My lordship, pardon us.
Supposing instead of the election commissioner, isn't it, excluding his name, other members are there in the panel. You are not agreed with that?
We are not agreed because everyone is an independent.
Can-
Indeed, my lordship. The council will further state that in the case of the council will further argues that in such circumstances, executive cannot be a sole participant in the appointment of the members of the election commission, and it gives an unfair discretion to the ruling party to choose someone who is to themselves and also supporting their own views of political dilemma, my lordship. The council will further humbly directs the court to refer to the page number 23 of the memorial of the petitioner, which clearly states that democracy is thus about collective decision making, and the principles of democracy have been held as a part of the basic structure of the constitution, has been upheld in the case of the Bharati versus state of Kerala in the year 1973 in SCC 225 notes. The council would further state that in the promoted the basic structure.
Please read the amended class,
Indeed, my lordship.
which consists of not single member.
Indeed, my lordship.
Isn't it?
Indeed, my lordship.
So overall, those persons who are there in the ruling governance.
Indeed, my lordship.
Now we are incorporating a judicial member also.
Indeed, my lordship.
It must be preferably the Supreme Court, the Chief Justice, or else any other person who has been recommended by him.
Indeed, my
So do you think any decision will be taken, I think against their wish?
The matter is that here in lordship, the Prime Minister and the election commission in office decide for a particular wish, and if
He is a single member. So the
my lordship,
incorporate.
the Prime Minister can also indulge in the similar position, my lordship, when he gets the point of view.
So you don't want Prime Minister also to be there.
No, not like that, my lordship, but we don't want the chief election commission to be in office, to be present in this election committee. We need at least an expert, my lordship.
What kind of expertise you require?
Uh,
Do you tell that the whole committee need to be reframed, or it is
no, my
about?
ladyship. Indeed, no, my
Okay, so as my brother judge was telling, it is about one or two people who are in
One
the.
people, my lord.
Yeah, could you substitute? Is the council has any suggestions on that?
The suggestion can.
Because you are bringing up some expertise in
Indeed,
that.
my ladyship. Indeed, my ladyship. The matter here is that the chief election commissioner, pertaining to his own authority, he possesses as an election commissioner. But whereas if there is an expertise instead of the commissioner,
What kind of expertise
the
you are
person who
expecting?
hold any kind of any opinion
Don't
or
get the
anything.
logic of it.
No, when there is-
Commissioner who is declaring. Now he is saying this is the party which has won.
Indeed, my
Isn't it?
lordship.
You have agreed, you are just satisfied with the decision taken by the election commissioner for over a period of 76 years.
Indeed, my lordship.
But when he has been incorporated as a member, just along with other members, isn't it? To see to the feasibility of whether this person can be considered or not. Now you are very pointedly saying he is a person who is not to be relied upon. Is it fair?
My lordship, the council would inhibit an extra question is there. It had been 76 years, and why not any amendment made before this kind of?
Why you not come before this court? Asking the government to do it.
We did it on.
When there is a constitutional mandate, which has been there dormant, not being implemented.
Indeed, my
No,
lordship.
you have become after 76 years, on a pretty day, you have awakened.
Indeed, my lordship, this was upheld in the case of Anubaranka, where we demanded a separate law and legislation, which until it is enacted, the case can be.
So more than your law, they have brought an amendment now. You
My
must be
lordship, the amendment which clearly says it does
this clause will be redundant. So when a change has been done in the, I think, very, constitutional provision itself. Is that it? Only when I think a separate statute is there, naturally this clause will be applicable.
Indeed, my lordship. Here, the amendment is not. It's not a kind of a direct law, my lordship. Under Article 13 of Clause 4, my lordship. So it cannot be inculcated as.
So your challenge or your point of argument on the residuary clause has no application.
My lordship, pardon, my lordship.
No, the last in the inconsistent clause
Indeed, my
will
lordship.
have no relevance in your argument.
My lordship, what if the future arises being a biased party elected as in this position of important.
No, you are challenging the very amendment, not any law,
Indeed, my lordship.
which is corollary to it.
Indeed, my lordship.
Good. Please continue.
Indeed.
Yes, just a minute. You have stated that democracy is thus about collective decision making. You referred to your ruling now, isn't it?
Indeed, my lordship.
It is a collective decision making.
Collective decision.
For a collective decision making only, this amendment has been made. To consult with all the important persons, this amendment has been brought in.
Indeed, my lordship.
So how can you oppose this?
The collective decision making process involves when all the 5 members in the committee have the same motion on decision making process, my lordship. Not biasly thinking about their own political party and benefit of their ruling party.
You cannot give reasons without any basis.
My lordship, it has been stated as in the basis in the proposition itself, my lordship. In the paragraph 4 and 7 of the
As per your argument, you have stated that the expertise to election, he must be selected. He must be appointed. Yeah, expertise for the election officer has to be selected, isn't it?
He is not an expert, my lordship.
You made an argument stating that the expertise must be appointed.
Instead of chief election commissioner, my lordship.
Chief election commissioner, for that only.
Let me, I think, make your job easier.
My lordship.
So deleting the person election commissioner, supposing we use a word "and" in between the Supreme Court Chief Justice and the Supreme Court Judge. Will you withdraw your challenge?
Indeed, my lordship.
Will you withdraw your challenge?
My lordship, it depends upon the few.
No. You said your point of argument solely on the inclusion of a person in the cadre of election commissioner. I am using your job now.
Indeed, my lordship.
So
the
we just pass an order deleting the person from the purview of selection committee, and instead of putting R, we bring in the Chief Justice of the Supreme Court along with the judge.
Along with
The Supreme Court judge.
okay, indeed, my lordship.
So will you withdraw the challenge?
Indeed, it is not. We can't assume the facts, my lordship, and we can't assume the amendment because the matter in here is that we have an extraordinary.
Now we try to consider your argument. Since your focus of your argument is only on the
To remove this
inclusion of the personnel.
Indeed.
Is that it? Supposing the court is obliged to delete that particular person and in his place bring in another judge.
It depends upon the judiciary discretion.
Counsel, you are not giving who the expert is, and we are proposing one more expert who would be a Supreme Court judge. And still there is no clarity on your part accepting the committee or not. Because initially you agreed that it is not about the committee, it is about the committee members.
Indeed, my ladyship.
And the court now is considering your contention, including the election commissioner, and we are proposing there could be one more Supreme Court judge. But still there is no clarity on your part.
Indeed, my ladyship, the counsel would substantiate an argument. The matter in here is that appointing and why there should be an appointment of another judge instead of having only one judge.
So the bench understands that whoever the expert we are going to propose or based on that, the petitioners are not going to accept it.
Yes, please continue.
Yeah.
Indeed, my lordship. The counsel would further substantiate with the argument is that in October 23, when the amendment of, before the enforcement of the amendment 106 constitutional amendment, the union government replaced the chief election commissioner and the governor in 10 states, my lordship. And this has implies the union government clearly execute this strategy in a broader view.
With regard to the proposition what we suggested to you,
Indeed, my
your
lordship.
argument has no base. No, that's it.
The basic argument is that the member of the selection committee can act bias infringing the
I think we are conceding your demand.
Indeed, my lordship.
So your point of argument is solely on the inclusion of a personnel in the cadre of election commissioner.
Indeed, my lordship.
Isn't it? Whether he has been removed or not, that's totally immaterial.
Indeed, my lordship.
Isn't it? The purpose of adding him is for a specific purpose, that too on the recommendation of a committee. Isn't it? Since you are challenging it, we are coming with a different option to delete his name. Now the point of argument is that, supposing if the name is deleted, will you be having any other valid point to challenge the amendment?
We don't have any valid.
Very good, very good. Go to the next.
Indeed, my lordship. Indeed, my lordship. The council humbly argues that the basic structure of the constitution will be said as the supremacy of the constitution and also the republic democratic form of government has been violated. The council would further conclude the issue, stating that the 106th constitutional amendment passed by the union government is transgressing the constitutional principle and violation to preamble of the Constitution of India.
See, how do you say that it alters the basic nature of the constitution?
Indeed, my lordship, here the sovereign power of the executive committee in issue 1 the governor and in issue 2 the sovereign power of the existing committee is being violated, my lordship. The council would elaborately discuss about the Lok Sabha person who is being elected. In the proposition it has clearly stated the person.
You know what's meant by sovereignty?
My lordship,
What do you mean by sovereignty?
the supreme power of a particular authority, my lordship, and the constitution, the rule of law, my lordship.
How do you attribute to an individual?
When it is stated in the art, such as when the constitution guarantees to a particular.
Please continue.
It was pointed out to the code of law. With the bench satisfied, the council welcome my council for the.
Hey, please take your proportion para 3.
Indeed, your lordship. Proposition.
Para 3. Third line.
Indeed, your lordship.
Sorry.
The office of the election commissioner is considered the most unstable as in the past 10 years, and some chief election commissioner have vacated their office before completing 3 years continuously in office.
This is your sole ground?
Indeed, my lordship.
Yes. Have you read the Indian Administrative Service Status Rules 1954? Have you read it?
If the bench permits, the council would refer for the civil and the internet, my lordship.
Because the Indian Administrative Service Rules 1954 says this commissioner is a secretary level post. It's not required any sealing. Because unnecessarily you are filing based on the illusion. So therefore you are not having any grounds to challenge it.
My lordship, the basic ground is that the chief election commissioner, if he is not in bias or if he is not in the favor of the party, can directly be into this amendment.
There is no.
The proposition is stand by clearly on the paragraph 3. It clearly states for the sole ground, and also in the paragraph 7, which has clearly stated that the 2023 election, 13 regional party formed an alliance, namely, and these National Liberation Alliance with Indian Democratic Party, and also the consolidated submitted report on October 2023, and meanwhile the chief.
Please answer to the question. Don't be just going back to the facts and then narrate it again.
Indeed, my lordship.
Answer the question directly.
Pardon, my lordship.
Your sole ground is before completing 3 years, the offices have been vacated, right?
Indeed, my lordship.
The election commissioner officers are the secretary level post by the IAS cadre, right?
Indeed, my lordship.
The Indian Administrative Service Cadres Rules 1954 says, in any secretary level post, there is no ceiling for the post, right? Have you read it?
Prove the how can it cannot possess a ceiling power, my lordship? Because when it
Without reading the provisions, without proper working the case, you are simply filing the case based on the illusion.
Indeed no, my lordship. It has clearly stated in the paragraph 8, the opposition criticized this as a political tactics of the ruling party to influence the upcoming state assembly elections, my lordship.
No. You misunderstood that and filed the case.
And indeed, my lordship, the council would here substantiate with the argument that the chief election commissioner take part in the appointment
Counsel?
of
You have seen nearly 26 election commissioners
Indeed,
in
my
India
lordship.
during this period.
Indeed, my lordship.
Isn't it? Do you think the mode of their appointment is fair?
The facts is not clear about this similar, my lordship. We can't decide upon.
The fact shows, nearly 26 people have been appointed. That should be election commissioners.
Indeed, ma'am.
Now the simple question is that, are you satisfied with the way the appointments are made, their performance of the function in conducting the elections? Isn't it? Are you satisfied with this?
No, my lordship.
No. So that's the reason they have decided different mechanism.
Indeed, my lordship.
Okay? It's a value addition.
Indeed.
So instead of 1 or 2 person deciding who need to be the chief election commissioner, now we have brought a body.
Indeed, my lordship.
Isn't it?
Indeed.
Now how do you say this is not going to, I think, affect the very basic structure?
The matter is that in 2023 there was an
Now the amendment is more what you are implying it as nullified.
the materialistic or substantive argument by the council is that when the chief election commissioner comes behind with
Again you are going to the election commissioner. We considered the point.
Indeed, my lordship.
Good. Conclude your honor.
The council would invite me co-counsel for the argument.
Yes.
Greetings to the bench. Council will humbly seeks the permission to address the bench as your lordships and ladyships respectively. Much obliged, your lordship. The council appearing here is to deal with the issue of whether the amendment in the Representation of People's Act is constitutionally valid. The council for the petitioners humbly submits before the Honorable Supreme Court of India that the amendment pertaining to the Representation of People's Act is constitutionally invalid. It is against the basic structure of the Constitution and also violates the fundamental rights guaranteed to the citizens of India, your lordship. It is humbly submitted that it is this amendment.
What is the fundamental right which has been infringed upon?
It is the freedom of expression that is being guaranteed to people of India, your lordship. It is contended here that
It is expanding, rather expanding the freedom of expression.
it is said that
The thing is that the statutory right of exercising your vote in favor of a particular individual has been more defined in such a way, you are compelled upon to come to the polling booth to exercise your option.
Indeed, your lordship.
But it is rather an expansion of your right. How do you say it is infringing your right?
But that cannot be done in a means of compulsion, your lordship. Since it is a democratic country, it is said that the people's will has to be respected. In that way,
So you have the sensitivity of coming to the court to challenge a constitutional provision,
indeed, your lordship.
isn't it? So we appreciate the gesture. At the same time, what's meant by fundamental duty?
Indeed, your lordship.
Okay, are you not having a basic duty of exercising your vote?
However, your
The
lordship,
precious right which is given to you?
however, your lordship, it is the duty of citizens to follow the fundamental right, but it is not enforceable before the judiciary, your lordship. In that situation also, it is said that fundamental rights and fundamental duties are to be read together in a parallel sense. In such case, we are contending here that the sanctions that is being provided for in case of any violation or in case of not coming to vote,
Now please read the first proviso in fundamental duty.
first provision. Kindly let me refer to this one. Lordship, it states that to abide by the Constitution and respect its ideals and
So what is the ideal which has been proposed in this proviso?
the ideal is to vote for the upgrade.
Doesn't say so. What is the ideal which has been preached by the constitutional provisions?
To abide by the Constitution.
What is the preamble? You need to refer to the text.
Indeed.
You come with the word democratic,
The ideals refers to the respect to respect the Constitution.
Do you have a word called as democratic in the preamble or part of it?
Indeed, Your Lordship.
Good. This is the ideal,
Indeed, Your Lordship.
isn't it?
Indeed.
To promote the ideal, you are given a right and it's also imposed as a duty now.
Indeed, Your Lordship.
But you are now saying I will not exercise my right. Neither I will follow the duty.
However, Your Lordship, it is said that force-feeding democracy is undemocratic in nature, and that has been discussed in the Law Commission report, 255th Law Commission report also, Your Lordship. It is said that force-feeding simply democracy, that compelling people to come here to vote is simply against the will, such that in a manner that people would express their willingness to vote by not participating in it, Your Lordship. It is the right of the people to participate in the election.
That is why your rights are crystallized under 79D of the Representation of People Act. You can even express your displeasure in voting a person.
Your Lordship, it is said that in 79 clause D of the Representation of People's Act, it has been discuss about the electoral right of a person. But indeed, it is said that a statutory right is always prevailed over by a fundamental right, Your Lordship. In that,
If you have displeasure over all the candidates, you can exercise your displeasure by voting not all.
indeed, Your Lordship, there is an option to note up, but in such scenarios, in certain scenarios, Your Lordship, there have been circumstances where, at the current scenario, there have been circumstances of the EVM machine being errored, and under certain, the council would like to refer to certain.
That has no relevance to your argument. See, EVMs can be tampered or not is not the issue before the court. All that is that you are supposed to make your exercise your franchisee in support of democracy. It is not it is not an undemocratical act.
Also, Your Lordship, here is the contention is that since there would be situations for the citizens where they would be in a manner like they are in a wrong area or far from the election dates at the time of
That is why you have got the provisions for postal votes.
Exemptions are there.
Exemptions are there, postal ballots are there.
Also, Your Lordship, it is said that it is only for exempted to a certain condition that only after three exemptions and the fourth exception, they are giving the
No,
notice.
only when you don't exercise your franchisee, you will be called upon to explain. So you offer your explanation, it is not going to, demoralize you.
It is the contention before the court that that is the section 62A clause 1, the council would refer that this particular clause is arbitrary in nature.
How do you say it's arbitrary?
It is arbitrary in nature to the election commission, Your Lordship. It is said that, however,
Now,
the
assume for example,
Indeed, Your
if the product class wherein on your failure to exercise the vote you are imprisoned, you are put in the jail,
Indeed, Your Lordship.
then you can say it is an arbitrary exploit violating my right, fundamental right. Isn't it? Now they have merely said, being a literate society,
Indeed, Your
when nearly more than 70% of the population are literates,
Indeed, Your Lordship.
when we enjoy a glory that a democratic process has been successfully implemented in India
Indeed.
for over a period of 76 years, they want to refine the electoral process.
Indeed, Your
It's a
Lordship.
reform.
The council would like to refer to the clause that has been reiterated that, however, the election commission shall be empowered to exclude certain classes or category of people from clause 1 with reasonable consideration, Your Lordship. But it is ambiguous that which category of people or under which certain classes that is being excluded by the election commission. In such scenarios,
That is the botheration of those people who are aggrieved.
Your Lordship,
Now,
it is.
are you coming as a proxy for all others who are there in the society?
It is said that Indian nation is fully.
See, it is for the election commission to take upon a call. They can always issue circulars as and when the election is going to be scheduled.
Indeed,
So it is the prerogative right who is to be exempted or who is not to be exempted or which are the categories of people they will be exempted. It is for the election commission to take a call on it.
Indeed, Your Lordship, but in such scenarios, in certain scenarios, if the election, here the provision clearly states that the election commission shall be empowered, which means that election commission at scenarios, it would make a large number of group of people not to come to voting.
Amendment has not come into force. So whatever you are advancing as an argument is merely hypothetical.
Indeed, Your Lordship, to prevent the matter.
How do you foresee? Now be optimistic rather than a pessimistic.
Indeed, Your
So
Lordship.
I think you have seen a law, you have not seen its working mechanism.
Indeed, Your Lordship.
So you are not agreed that so many people without justification have been put to punishment.
Indeed, Your Lordship.
Now on assumptive way you are just challenging the constitution.
Indeed, Your Lordship.
What basis is there for it?
Your Lordship, Your Lordship, it is the basic structure where democracy ensures that there must be a fair and reasonable manner.
How the fairness has been stumbled now?
Your Lordship, here it is said that there are certain people that is being excluded, but there is an ambiguity in this, Your Lordship, because it violates the article of.
How to fall in line with your argument?
Indeed, Your Lordship.
Assume, Prof, I am bedridden,
Indeed, Your Lordship.
so I am fatally sick,
Indeed, Your Lordship.
isn't it? Do you still want me to come to the polling station and exercise the vote? When I will not be there to see who is the person who has won because of my voting.
Indeed, no, Lordship.
Okay, these are the classes who are exempted.
But it is not expressly implied in the.
That is the botheration of the election commission. Why do you hesitate it?
It is said as the discrimination of people being excluded as a certain classes, Your Lordship. That is what the contention before the Honorable Court.
Any other point?
Your Lordship.
Any other specific point? What's the challenge of this provision?
Your Lordship, it is said that clause 1 is ambiguous in nature, and so it is arbitrary to the power of the Election Commission, Your Lordship. And to further state that the sanctions that is being provided, it is said that the word is not clear. The particular clause 1 is not clear about.
Clearly on ambiguity, you cannot come before this court.
Indeed, Your Lordship, the main contention is about the arbitrariness of the Election Commission to exclude certain classes under this ambiguity, Your Lordship.
That's all. Any other?
Then further the Council would like to move on with the section 62B, in which there are certain sanctions which violates the fundamental rights guaranteed to the citizens of India. Your Lordship. It is said that a non-voter with 4 consecutive notice shall be punished with fine or declared ineligible for application and employment in government jobs, Your Lordship. It is said in the case of Nagaraja and others versus Union of India, it is said that it is both the articles to be read together in a parallel sense. They give a positive command to the state that there shall be equality of opportunity of all citizens in public employment, Your Lordship. It was further held that Article 16 Clause 1 flows with the Article 14, Your Lordship. And
Here also equality of opportunity is given to all the voters.
Indeed, Your Lordship, but the main contention is about the sanction that is being violation.
Your pick up the case may not
Not provided to you, then you can bring equality provision and you hold a voter's ID also.
Indeed, Your Lordship.
Then
But, Your
it
Lordship,
means you are partially agreeing upon to cast a vote.
Your Lordship, it is said that merely for the reason of non-voting and a sanction that has been deleting a person from being ineligible.
When it comes under a duty, it is the obligation of the citizens, towards the citizens, to oblige it, to perform it.
Indeed, Your Lordship, but this stands as an arbitrary in nature, so that it is not.
So the problem is about the punishments, which has been vested in that. And in the word you have used sanctions, and not about casting a vote. What do you say?
Your Lordship,
Does the council agree then? Casting the vote, we agree, and we don't agree with the punishments.
it is said that.
Is that so?
Your Lordship, there are certain sections that has been
answer
challenged.
the question. Are you satisfied now?
Indeed, no, Lordship, the council would.
Will you consider to withdraw?
No, indeed, no, Lordship. The council would like to classify difference. That is that clause 1 is.
Please
being-
remember,
Indeed, Lordship.
by virtue of amendment in the statute, they brought two, specific, conditions. One thing is that to bring in all people who are having an adult suffrage to come to the polling station, exercise the vote.
Indeed, Lordship.
Mandating everyone to exercise the vote. The second point is that anyone who was willfully,
Indeed, Lordship.
wantonly refrains from exercising the vote, there are certain sanctions which has been postulated. It is not implemented, it is only framed.
Indeed, Lordship.
Isn't it?
Indeed, Lordship.
Do you want someone who is given a precious right of exercising the vote,
Indeed, Lordship.
isn't it? Which is spoken as an ideal, which is also given as a duty.
Indeed, Lordship.
In spite of it, I will be there in the social atmosphere, but I will not be participating. No, you give me all the rights.
Your Lordship,
Is it fair?
Your Lordship, it is said that.
Now, any right which has not been exercised,
Your Lordship.
so which is really futile,
Indeed, Your Lordship, but the fact is here like that it is not.
Again, there is a rider which says it is not done arbitrarily. Anyone who has not come to the polling station has been given a notice for the purpose of giving an opportunity to him. What is the reason which forbidden him? Not once. It happens 4 times.
Indeed, Your Lordship.
Isn't it? When the logic is that when someone has been given a right, in spite of it where he has not exercised,
Indeed, Lordship.
what's wrong in curtailing it?
Lordship, it is said that if a scenario arises like such as.
Now please remember, in the parlance of limitation, you are given a right,
Indeed, Lordship.
isn't it? But you are not invoked it. You have not gone to the court of law to bring an action. Isn't it? After the period of limitation, in spite of you possessing a right, you are deprived of coming to the court of law. Is it right or not?
The council understands the point.
Very good. The same way, you are given a right, which right you are not exercising for a continuous period of 4 times.
Indeed, Your Lordship.
Now,
that
4
is
times
not
means,
the
please
main-
remember, in the normal circumstances, it takes 20 years.
Indeed, Your Lordship.
Normal circumstances, I am putting it.
Indeed, Your Lordship.
So the implication is that you have a right which you are not interested in exercising,
Indeed, Your Lordship.
and the statute deprives it. They are not giving you the right to vote again.
Indian Lordship.
What's harming?
Your Lordship, it is not with the intention of the citizens to continuously not voting, Your Lordship. It might be in the circumstances such as which would be regarding the circumstances or factual circumstances according to the citizens, Your Lordship. In that manner, it would be in the sense of arbitrariness, or it would be unreasonable to punish with such sanctions, Your Lordship. And thus it is concluded that the amendments pertaining to this Representation of People's Act is in violation of Article 14, 16, 19 and 21 respectively, Your Lordship, since confiscation of passport restricts the right to travel abroad, which has been held by the Maneka Gandhi vs. Union of India before this Honorable Supreme Court, Your Lordship. Also, the Council would like to add upon a point regarding the issue 1 and 2. That is the factual contention of.
I think that has been not put forth by your colleague.
Indeed, Lordship, if the Council, if the Court permits.
We have exceeded the time. Please conclude.
Indeed, Lordship. Much obvious. The Council would conclude that it is in violation of fundamental rights of 14, 16, 19 and 21 of the Constitution of India, Your Lordship. Therefore, the Council only seeks permission to go for the prayer.
Easily. Take your prayer portion. Take your prayer portion.
Yes, Your Lordship.
Just take your prayer, read your prayer.
Therefore, in the rights of issues raised, arguments advanced, and authorities cited, the petitioners humbly pray that the Supreme Court of India may be pleased to adjudge or declare that the amendment pertaining to the appointment of Chief Minister affects the Constitution.
Wait. What kind of regulation you need? Because all the Moot participants and the law students must know that the pleading is very most important to the case. Prayer is very, very most important to the case. If you are the petitioner side, you must need, because the writ petition in either High Court or the Supreme Court, the writ petition is valid. The declaration, writ of declaration, or writ of mandamus, or writ of certiorari, you are seeking a relief of quashment of the provisions, clauses, or you should seek declaration. Declare that the provisions of amendment is null and void, or invalid, or unconstitutional, or ultra vires. There is no specific words in your prayer. This is a mode of prayer.
There must be
Who has done
specific,
it?
no?
Because why I am saying that all the students must know. Hereafter you are going to practice. In repetition, you should mention about the prayer. Either five mandamus, 5 writs.
The nature of the writ which you are seeking.
Just no issues. Just now mold and read.
Also, it is said that or pass any other order it may deem fit if the court.
No. What sort of writ? See, there are 4
Specifically.
types of writ. Mandamus,
Specifically,
certiorari,
In that case,
declaration.
the specific prayer. It can be called with the residuary.
You are appearing before the Supreme Court.
This is the highest court in the country.
The Council would, we pray, therefore in the right of issues raised and arguments advanced and authorities cited, the petitioners humbly pray that this Supreme Court of India may be pleased to adjudge or declare that the 106th Amendment is unconstitutional or pass any other order it may deem fit in the interest of justice, equity and good conscience, for which the Council for the petitioners shall be duty bound forever.
So okay, hereafter you will do it properly.
Much obliged, Your Lordship. It was honor argument before the Honorable Court. Much obliged. Thank you.
Yes. Yes.
The Council seeks permission to collectively address the bench as Your Lordship. I am the Counsel for the respondent, the Association of Democracy and Others versus Union of India. If Your Lordship is well versed with the facts of the case, may the Council move to the issues. Much obliged, Your Lordship. I'll be addressing issue 1 and 2 for 15 minutes, and my co-counsel will be addressing issue 3 for the rest 15 minutes. So firstly, the issue being whether the amendment pertaining to appointment of Chief Minister affects the constitutional position of the Governor, Your Lordship. The respondent humbly submits that the constitutional position of the Governor is preserved. Firstly, the amendment introduces an election commissioner with whose consultation the governor shall call upon the party or pre-poll alliance when no party wins a majority, Your Lordship. According to the constitution, the governor has discretionary power to appoint the chief minister. In a situation of a hung assembly, I would like to substantiate the same by stating the case of Mahabir Prasad Sharma versus Prafulla Chandra Ghosh, where the court held that the governor, in making the appointment of the chief minister under Article 164 clause 1, acts in his sole discretion, Your Lordship. Further, the role of election commissioner here is only consultative, Your Lordship. I would like to substantiate and bring to the court's attention the meaning of the word consultation here, Your Lordship.
What is the necessity of bringing this class after 76 years?
Your Lordship, the facts, as the fact sheet stated, the situation prevalent in Syria, it is famous for its history of hung assemblies, Your Lordship, and coalition governments. So in such a scenario, where there is so much uncertainty and political instability, it becomes very important to appoint the right person for the position of the chief minister, Your Lordship.
So, do you mean to say that the pre-poll alliances are all authorized by the election commission?
No, Lordship.
Then what was the necessity for the governor to go and consult an election commissioner, chief election commissioner?
Much obliged, Your Lordship. Previously, the governor was appointing the chief.
Even today, even without the consultation of the chief election officer, he can always call upon the party to show their majority by floor basis.
Much obliged. Indeed, Your Lordship. The sole discretion remains with the governor, Your Lordship. He shall appoint the chief minister in his sole discretion. However, the role of the election commissioner here is only consultative, Your Lordship. And
the role of election commissioner stops with the conduct of elections.
Your Lordship, I would like to bring it to the bench's attention, where I would like to highlight the Article 192 Clause 2 of the Indian Constitution, Your Lordship. And I would also substantiate the same by stating the case of Election Commission of India versus Dr. Subramaniam, page 10 of the compendium, Your Lordship. The decision pertaining to disqualification of members, which made final in that decision.
No, that has no relevance to your case.
Your Lordship.
Please substantiate your point with regard to the case which is relevant.
Much obliged.
So the thing is that you will be losing your veracity
Much obliged, sir.
on the point of your argument if you are going for a case which is totally unrelated. So the very basic question which has been put by this floor is that what is the necessity for you? What is the urgency which is shown by you in coming with an amendment of this nature?
I would like to address the question of your Lordship, which stated that there is a limitation, and the limitation ends with the conduction of election. The role of election commission ends with the
Election commissioner.
election commissioner.
Time being, just keep him aside. Exactly. So you have been running a system of election of the chief minister by virtue of the Westminster pattern, where elections have been conducted by you successfully, and it has been glorified by the whole communities. Now that all of a sudden, after 76 years, you come with a class. So wherein you are just bringing in a different contingency. What is the necessity for it?
The necessity lies in the facts of the preposition, Your Lordship. The country is famous for its history of hung assemblies, Your Lordship. So, in this situation where coalition governments are high, so it is very uncertain that which candidate will be very much efficient to fill the position of the chief minister, Your Lordship. Your Lordship, the election commission which is here, according to Article 324, Your Lordship, it has the superintendence and control over the conduction of elections, thereby being the most suitable body for consultation, Your Lordship.
We are speaking about the power given to the governor to decide who need to be called to form the government. Kindly don't read on to the election commission position. That's an entirely different thing. Isn't it? Now that when you have an option to decide who need to be called, which has been working very successfully, what is the urgency for you to come with an amendment?
Much obliged, Your Lordship. This, as Your Lordship rightly pointed out, the governor shall appoint the chief.
An election commissioner will be to rather give his opinion to an constitutional body.
Your Lordship, the Election Commission, according to Article 324, Your Lordship, has the widest authority, and I would also like to substantiate my point by using the case law of
Please don't read on to the cases. How many election commissioners you have seen in this Indian society?
Your Lordship, 26 Chief Election Commissioners as
What
stated.
is the necessity for so many people being appointed as election commissioners?
Your, Lo-
And what is the tenure of the office?
Your Lordship has stated 6 years, Your Lordship.
6 years. So during the period of 76 years, how many election commissioners ought to have been there if they fulfill the term?
If they fulfill, nobody completed 3 years of term. If they had to fulfill 6 years, it would be double, Your Lordship. So,
So possibly, if you are very strong in mathematics, possibly it would be 3. But now that you have brought in nearly 26 personnels. That speaks. The thing is that how you are selecting a person. Isn't it?
Your Lordship,
The thing is that the scheme of appointment of the election commissioner itself is not fairly done. That's the implied meaning of it.
Indeed.
So there are very many cases where election commissioners have thrown the office and gone away.
Indeed.
And even with the facts it says, after assuming power, you have thrown somebody out.
Indeed, Your Lordship.
Okay? Now how reliable it is to have a consultation with him?
Indeed, that is the reason why we got the second amendment, Your Lordship, with pertaining to the appointment of the Chief Election
Please
Commissioner.
remember, in a country where the chief election commissioner's position has been in a very dilatory position, you are bringing it into the constitutional parameter where the governor is given power to have a consultation. How fair is it?
Your Lordship, it's entirely fair, Your Lordship, because we are not affecting the constitutional position of the governor in the first place. The role of the Election Commission is only consultative here. So, as consultative, it adds to the value and the information needed by the governor.
What competency the election commissioner has to give the prerogative to the governor to have a consultation with him? What special quality he has?
He has total knowledge.
He is a mere personnel who need to supervise, conduct and result the publication of the result. Isn't it? His job is entirely different.
He has.
If he is playing a role to decide who has to be there as the chief minister, so definitely this is something unfair,
Your Lordship, however, Your Lordship rightly pointed out, the power and functions of the election commissioner is entirely with the conduction of elections. Thereby, he has all the information necessary so that the governor chooses the right.
What information will he have?
Sir, Your Lordship.
What special information he'll have?
Your Lordship, when there is a hung assembly, when the situation is
Supposing there are.
What is his role to play?
He can have information about the intricacies, Your Lordship. Sensitive information of the elections.
His electoral alliances.
What specifically you want to tell? What specifically that consultative means?
He adds to the value of your Lordship, as rightly pointed out, the governor shall appoint the Chief Minister, Your Lordship. However, his appointment process is flawed in certain circumstances, as he does not hold the complete knowledge about the working of the Election Commission, Your Lordship. But this knowledge is...
Please understand the question and make it relevant. Isn't it? In case where the electoral rates have not identified it, it's a clear majority. In such contingencies, you are postulating a mechanism wherein the governor need to consult the election commission. Isn't it?
Indeed.
Now the question which has been put to you is that what special qualification, what special information he can pass on to the governor to identify the person who need to be appointed as a chief minister?
Much obliged, Your Lordship. It could be the voter turnout or which party scored more and or which...
All our basic information, not even the election
Already
commission
available.
requires to tell. It is available. What's the point including this election commission?
Now is there any
Giving a
electoral
special
alliance
power.
which is done with the consultation of the election commission in India?
Right now, no, Your Lordship.
And is the.
Can they play a role in pre-poll alliance?
I beg your pardon, Your Lordship.
Can the election commission play a role in pre-poll alliance?
Your Lordship, indeed, Your Lordship.
How?
Your Lordship, as stated in the amendment, the governor will call upon the party or pre-poll alliance in consultation.
See, the election commission has no role to play in the pre-poll alliance. Pre-poll alliance is not certified or approved by the election commission. In that event, why do you want the election commission's presence?
Your Lordship, here the amendment still now lines with the constitutional position that governor will never
Let's choose the election chief minister
No,
in
we
his own
feel
discretion.
that it is undemocratical to call upon an election commission to give suggestions to the governor. It is already there. The existing procedure is whichever party has got a high number of seats will be called to form government and exercise their floor test.
However, when there is a situation of a hung assembly, when there are
Now let me, for I think no information. So the development which are going in the Bihar is a typical example. Today. As on today. Isn't it? So it speaks volumes about the formation of coalitions, formation of alliances. Anything may happen in India. In such scenario, how fair is it on your part? A person who has been at the mercy of a prime minister, wherein the president has no other role except to give an appointment. How fair is it to impose on the governor to have a consultation with him?
Your Lordship, we are not imposing on the governor. It just plays a role of an advisory body, Your Lordship. Thereby adding inclusivity and diversity in appointment process, Your Lordship. Thereby upholding the fair and just appointment process, Your Lordship. We are reducing arbitrariness in the appointment process, Your Lordship. Your Lordship, however, the
Just
information...
read the class. Second para in your amended, proviso. Where no party won a majority, the governor
shall in consultation
what's the meaning of this shall?
Shall, in the sense, the governor shall consult.
What is the imprint of this word shall?
He should consult.
Okay. Is that not a mandate?
It is a mandate.
Is it not a compulsory class?
Your Lordship, I would like to justify this.
No, answer whether it is mandating or not.
The word shall is.
Yes.
The word compulsion, according to the judgment held in...
They have not put a clause where may.
Your Lordship...
So please remember, they have done with a clear intention.
Your Lordship, the governor shall consult the election commissioner. But however, after taking their advices, the governor still act upon his discretion. I would like to substantiate the same by justifying the meaning of consultation, Your
What
Lordship.
discretion is given to the governor?
Your Lordship?
Because the word used is shall. It is not may. Supposing if it is may, then your argument that the governor has been given the discretion will apply.
Your Lordship, I would like to bring the bench's attention to the case of SP Gupta versus Union of India, where they have
Supposing
explicitly...
if the pre-poll alliance party does not cooperate with one of the parties, there will be a stalemate.
Your Lordship, in such situations of intricacies which require more fair and a layer of advisory is the reason why this amendment of introduced, Your Lordship.
No, the duties of election commission is confined with representation of people's act. Not more than that.
Your Lordship, they also play a role in...
Disqualification of legislative members, Your Lordship.
That is quoted in the Representation of People Act, Section 8A.
Indeed, Your Lordship, the point the petitioner wanted to convey is that their role is not just limited to the conductions of elections, but also they hold an opinion when it comes to disqualification of legislative
No,
members.
disqualification is already codified under the Representation of People Act. So they discharge their duties under the Representation of People Act.
Your Lordship,
That has nothing to do with this amendment.
Your Lordship, with the changing circumstances, considering the situation prevalent in Sindhya, the amendment should be flexible to change this, Your Lordship, to solve the problem which is persistent here. The very necessity for introduction of this amendment, Your Lordship, is that to uphold a fair and just election so that no error
See,
occurs.
the Chief Election Commission cannot opine or pass on his opinion to the governor because it will defeat the mandate of the elected representatives.
Your Lordship,
Here, in the case of hung assembly only, Your Lordship, the election commission...
And the specific word of pre-poll alliance is still worst.
Your Lordship, the governor still has a discretionary power. Here, the role of the election commission is consultative. However, as Your Lordship pointed out, the pre-poll alliance, Your Lordship, in this matter also, the governor will still have
his discretion. Hence, issue 1, the constitutional position of the governor is preserved, Your Lordship.
Yes, continue. Go to the next issue, perhaps.
Much obliged to Your Lordship. Issue 2, whether the amendment pertaining to the Chief Election Commissioner transgresses the constitutional limitations and principles, Your Lordship.
representative of the People's Act, it can disqualify a member. Can it be to a party?
No, Your Lordship. It is basically
When that be so, what is the necessity to introduce the word pre-poll alliance?
Your Lordship.
Pre-poll alliance is not with members, it is with parties. What is the necessity to introduce that word in the amendment?
The crux of the amendment here, the purpose of the amendment is to ensure a stable government, Your Lordship. Whether it is in the form of pre-poll alliance or calling upon a chief minister who can prove a majority, Your Lordship. Here, the instability in the political situation prevalent in India, the amendment's purpose is to solve that political instability, Your Lordship.
So you mean to say this amendment solves the instability?
Indeed, Lordship.
It aims to solve the political instability prevalent in India. Much obliged, Your Lordship. Whether the amendment pertaining to Chief Election Commissioner transgresses the constitutional limitations and principles. The amendment is in line with the constitutional limitations and principles. I would like to bring in to the attention of the judges, as mentioned according to the facts in the deposition, Your Lordship, that the office of the Chief Election Commissioner is considered the most unstable, as in the past 10 years, Your Lordship, 7 Chief Election Commissioners have been vacated. So there is a flaw in the appointment process, as rightly pointed out in the facts of the case, Your Lordship. So this very amendment is subject to solve that problem, Your Lordship. There were allegations of bias in the appointment process of the election commissioner. Further, it was the need of the hour, Your Lordship, that a solution is provided in the appointment process of the Chief Election Commissioner, as it was flawed, as highlighted in the facts of the case, Your Lordship.
Read the main proviso, which I quoted to the petitioners.
The amendment, Your Lordship.
No, the unamended class. 324 class 2.
Much obliged.
Just read the provision earlier when you were the other side is arguing. 324.
Your Lordship, the Election Commission shall consist of the Chief Election Commissioner and such number of Election Commissioners, if any, as the President may time to time fix. An appointment of Chief Election Commissioner and other Election Commissioners shall subject to provisions of any law.
No, we just restrict the words. This is a constitutional provision which has been in operation for so many years.
Indeed, Your Lordship.
Isn't it?
Indeed.
More than all, I think the mandate which is given under the Constitution is that you need to bring a law. Isn't it? Which you have not done so far.
Your Lordship, here...
Now, are you agreeing with the point? You have failed to comply with the constitutional direction which is given to you to bring in a law to enable the constitutional provision to be exercised very fairly.
Your Lordship, that's what the respondents are intending to do by introducing this amendment, Your Lordship.
No, you have been hibernating for nearly 76 years.
Your Lordship,
all of a sudden today morning, no, you got a vision.
Your Lordship, the
has carefully observed the situation prevalent in India to bring about this amendment, Your Lordship. That's the amount of observation the government has showed.
Okay, so you are just trying to respect the constitutional mandate. No direction.
Indeed,
so
Your
that's the
Lordship.
purpose we have brought in.
Indeed, Your Lordship.
Very good. Now the proviso enables, it must bring a provisions of any law. What's the meaning of a law?
Law is a code of conduct, Your Lordship, which the citizens must abide with, else...
Now, is it a constitutional amendment or a separate law?
It's not a constitutional amendment, Your Lordship.
It must be a separate law. That's the mandate which you have not complied so far.
We are
No. Now you have brought in an amendment. Now the simple question is that, is an amendment which is incorporated into the constitutional provisions will be called as a law?
Indeed, Your Lordship. It should be passed by the legislature, Your Lordship. The respondent would like to readdress that.
So the clause which is coming after the unamended provision speaks about the mode in which an election commissioner is to be appointed.
Indeed, Your Lordship.
It should have come in a law.
Indeed, Your
You
Lordship.
have not brought any law for 76 years. Even now you have not done it.
Your Lordship, we have not brought it in the form of a law, but we have brought it in the form of amendment.
You agree to the point you have not brought in any law.
Your Lordship, it is passed in the
No.
legislature.
Do you agree to the point?
That we are not going to separate law, Your Lordship.
Yes, very good. Now, what's the purpose of the last class then?
Your
Read the
Lord-
last class.
Your Lordship, by
Read the last class.
provisions of any law
No,
made in
last class. In the same
the
proviso.
president or the governor.
No.
Oh, of the amended, much
No,
obliged.
not amended, unamended. It was there originally, now.
Last line.
The last line in the proviso.
The article shall have overriding effect over any law providing.
That is in the amendment, Your Lord. That's in the,
Last line of the amendment.
indeed, Your Lordship. It is mentioned, it is mentioned.
You don't have the problem with you?
Much obliged, Your Lordship. The article shall have overriding effect over any law prevailing.
So when you don't have any law, what's the purpose of including this class?
Your Lordship, it is subject to inconsistency of the.
When you don't have a law itself, which though mandated by the constitution, you have not done it for nearly 76 years, and you are not coming with a separate law, but you are bringing it as an amendment. Is that it? What's the purpose of including this class? And to my surprise, let me tell you, I have not seen a constitutional provision which uses the word will.
Your Lordships, in this scenario, it talks about other laws, Your Lordships, which is inconsistent to the provision
Only
mentioned.
when the law is there, then automatically we will come to the inconsistency part. When you don't have any law itself, what's the purpose of you incorporating a class of this nature?
Your Lordships, it is to ensure the independence of the Election Commission, Your Lordships. The amendment,
Did you understand the question?
Indeed, Your Lordships.
You agree to the point, in spite of the constitutional mandate which is given under class 2, though you are given a direction to come with a law, you have not done it. Even now you have not done it. You brought only an amendment. But whereas you are incorporating a clause in the same proviso, saying any law which is existing will be inconsistent. It is something redundant, you know. It doesn't carry any meaning.
Your
And
Lordship,
more than all, the included class, the amended class, after class 2, the second para it reads as, the selection committee will consist of. Isn't it? Let me tell you, the core value of interpretation of statute is that there is a specific meaning for using the word shall or will, which itself is not taken care by you.
Your Lordship, the meaning of the word will here is, it is necessary to make sure, ensure neutrality in the selection.
You want to interpret the word shall and will?
Your Lordship, the respondent is intending to convey here.
Kindly remember, the Indian constitution starts with the word we. Isn't it?
Indeed, Your Lordship.
So you can see in any of the provisions, even in the fundamental rights, they will be using only the word shall.
Much obliged. Indeed, Your Lordship.
Isn't it? Will come there only in the third personality. When I use first person, I or we, it must be only shall.
Indeed, Your Lordship.
So the very basic flaw is there in the drafting itself. Inconsistency class, and then the language which has been used. Isn't it?
Your Lordship.
No. Yes.
Your Lordship, the selection committee will consist. Your Lordship, this is used in order to maintain the neutrality within the election commission. Your Lordship, the selection committee should be a neutral body.
Deciding the questions arising after election.
Neutrality for what? Your Lordships, this is pertaining to the appointment of the Chief Election Commissioner, Your Lordships. The appointment of the Chief Election Commissioner should be held in such a way that it is free from executive biases, Your Lordships. So in such a way, where there is a flaw, according to the facts of the case, in the appointment of the Chief Election Commissioner, this amendment proposes to solve that very problem, Your Lordship.
You have also not defined the qualification for the election commissioner. Even though you have only defined the selection committee, you have not defined the qualification. What is the basis that they are going to select?
Your Lordship, of the election commissioner, Your Lordships, pertaining to Your Lordships, here the selection committee is a diverse and very inclusive.
What is the basis? What is the basis on which they will select? They should select a person with certain qualifications. That qualification is not defined here.
Your Lordship, that qualification is indeed silent and not explicitly spelled out in the very amendment, but The previous provisions will apply as that is not changed in this very amendment. It is just including an additional body who will consult the president in order to appoint the chief election commissioner. Here the amendment has 5 members, the selection committee has 5 members, Your Lordship, and the presence of chief election commissioner in the first place, who has the required expertise to appoint the upcoming chief election commissioner, adds to the expertise value of the selection committee.
You made the election commissioner post redundant. Something, where you have not given that with respect to them. So, from 91, now you have just subdued the power of the chief election commissioner by appointing 2 more personnel.
Your Lordship, this diversity is so there is to maintain neutrality within the election commissioner, Your Lordship. The Prime Minister and leader of opposition is there to maintain checks and balances, Your Lordship. And further, the CJA and Chief Election Commissioner being a neutral body is to uphold the fair and just appointment process, Your Lordship. Here, the amendment is trying to fix a problem which actually exists and need to be addressed on urgent notice, Your Lordship. That is what the respondent is trying to convey here. And further, it is in Anup Baranwal versus Union of India also, Honorable Justice K.M. Joseph justified such inclusion by stating that CJA's presence will act as a message that no mess up will happen, Your Lordship. Your Lordship, this selection committee was introduced in the first place to solve a problem that is persistent and highlighted in the facts of the case, and thereby doesn't transgress any of the constitutional principles and limitations, Your Lordship, but it is therefore amended in order to uphold the democracy and ensure the independence of the Chief Election Commission, Your Lordship.
Why you have not done so far?
Your Lordships, this situation was not pertinent. According to the facts of the case, Your Lordships, we have the history of India in recent situation. But from 1947, what was the history of India has not been brought to the light, Your Lordships. So, pertaining to the present situation, this was the most urgent and needed amendment, Your Lordships.
Any other point with respect to the issues?
Your Lordships, I would like to summarize the same and highlight that in case of Kamal Nath versus Chief Election Commissioner, Your Lordships, Election Commission was known for its nature of impartiality from its history of from 25 to 30 years, Your Lordships. It has been a neutral and impartial body, Your Lordships. Therefore, it is the right committee for the consultation, and its independence is maintained and ensured by the Second Amendment, Your Lordships. Thereby, both the amendments fall within the constitutional limitations. Thereby, the respondent ends their submission, Your Lordship. It was an honor to argue before this honorable court. Much obliged, Your Lordship.
Your Lordship, the co-counsel for the respondent would be arguing.
The amendment in Representation of People's Act is constitutionally valid, more so specifically Section 62 and Section 62B of the Rope Act. But before doing so and before moving on to the actual advanced arguments, the counsel for the respondent would like to invoke and request the judge's attention to the facts. The facts very clearly say, first paragraph, that in spite of the 77% literacy rate in the country of India, there is a contradiction.
Contrary to the expectation, this has not contributed to political participation. If anything, this only implies and is imperative that there is a need for voter maximization. One.
Secondly, in the next paragraph, in the completely next consecutive paragraph, it also says that the fact that India
emerged as the largest and one of the most successful democracy, the credit goes to the Election Commission, which sets up and makes it a constitutional body as the Election Commission has so in its right to do so. This very simply reiterates the trust in Election Commission of India that has been dictated upon by the history of India, which made it the mother of democracy, the largest democracy, one of the largest democracies in the world. Much obliged, Lordship. The same will be argued upon in the upcoming arguments. Firstly being, the very first amendment, that of Section 62A, is actually constitutionally valid. And in doing so, in arguing so, the petitioner has, the respondent has one very vital argument, that of a constitutional objective. This promotes an active and engaged citizenry, and making people more accountable, making people more democratic, and making them engagement. It addresses problems like that of apathy and disengagement, which is the need of the hour. Like the fact suggests, there is a need of the hour for political voter turnout, maximizing voter turnout, which is clearly the need of the hour. Further, in the case of Mohinder Singh versus Chief Election Commissioner, the state, the legitimate interest of the state was inherent, and it was said that it was inherent in maximizing voter turnout. This further amplifies my argument that talks about the state's interest in maximizing voter turnout. One.
What is the core value of a right, legal right?
Much obliged, Lordship. The core value of a legal right is, it is your foundational right that is to be upheld without any violation and without any contravention to anything that contradicts the same.
So do you agree to the point? My right to enjoy a particular thing, it also includes to avoid it.
Much obliged, Lordship.
Right to vote.
It includes a negative right as well.
It includes a negative right on me, right not to vote.
Much obliged,
How
Lordship.
do you want to forbear it?
Much obliged, Lordship. In the case of PUCL versus Unit of India,
for this, you need not go for a case law.
Much obliged,
The
Lordship.
question which has been put to you is right to vote includes right not to vote.
Much obliged, Lordship. It is a simple and statutory right, the right to vote, yes. But here, the Election Commission of India...
Neither the state is forcing a political opinion or is forcing anybody at all to have to vote for a certain political body.
Please remember, I am not putting the words in such a way to force you to exercise the vote in favor of somebody.
Much obliged.
It is right to vote. It is a precious right given to the voters.
Much
The
obliged.
voters. Isn't it? So the option is there for him to exercise it or not. Why do you compel him?
Much obliged, Lordship. Like the Council for...
Also using the accountable in between.
Much obliged, Lordship.
And it is going to be accountable, I think it's not that simple word. You are imposing something. Is that a criminal offense, not voting?
Much obliged, Lordship.
Using the word accountable, how come it is?
The council so used the word accountability because it fosters accountability when they are, when they are engaging themselves and indulging themselves in the very voter participation. Further, as the honorable judge's question, there is a negative right, yes, of course. However, like it was upheld in Mohinder Singh Gill and the very aspect of free and fair election, the state has a legitimate interest in maximizing voter turnout, and that the state isn't compelling anyone to vote for a certain political side, and there is always the option for a nota as well.
This legitimate expectation has not been respected and then tried to implement it so long.
Much obliged, Lordship. The council for the respondent has reasons to believe that is certainly the case because there is also...
Let me help you in a different way.
Much
You are
obliged, Lordship.
bringing in an amendment on two specific core things. You are interested in making everyone to come to the polling station and exercise the vote. It's a mandate. You are making it compulsory. Secondly, whomsoever will not come to exercise the vote, you are just going for imposition of sanction. What is the logic? What is the bona fideness or urgency in bringing these types of amendments into the constitutional provisions?
Much obliged, Lordship. As far as the question is regarding the mandate, that of compulsory voting, that very much is the need of the hour because in sight of increasing literacy rates and increasing population, the fact statements clearly say that there is a disproportionality here and hence voter turnout is important.
Which is disproportionate. When the majority, please remember, more than 70% of the voting has been recorded.
Much obliged, Your Lordship.
Isn't it? Which implies the majority are interested in exercising the vote and then decide their selected leader. But in such scenario, when you have other options to create awareness, to make people enjoy the right, you would have done other mechanisms. Why do you go for a specific law and then make it compulsory? And more than all, as my colleague has been putting it, you can bring in sanction only in such circumstances where it is causing some harm. So the basic core element of crime is that, an offence is that, there must have been some harm which would have been caused by the individual. Besides fulfilling all the basic elements. What's the harm which would have been caused if somebody is not coming to the polling booth?
Much obliged, Lordship. To further add to that, the council here would like to reiterate on the fact that impositions and measures and punitive measures are not being imposed on people just for not voting. This is for consecutive elections. 4 consecutive elections also implies more than 4 consecutive years, Your Lordship. So the state has...
You considered earlier, right to vote includes right not to vote.
Much
You
obliged.
considered, I remind you, you earlier considered right to vote includes right not to vote. Whether he is referring for 1 time or 4 times, it is totally immaterial.
Much obliged, Your Lordship. There is definitely a damage here to the... legal damage, not as such, but there is a damage to the state's interest. Much obliged, Lordship. As far as the concern is regarding the constitutional validity of these sanctions, the Council so believes that this is in fact proportional, as so it was stated in the case of Sunil Batra versus Delhi administration, where on conviction of a crime, your fundamental rights as well and certain rights can be restricted to a certain extent.
Non-exercise of vote will amount to a tantamount crime?
Much obliged, Lordship. However, the interest here that is being looked upon and the interest here that is being sought is maximizing voter turnout, because India is one of the world's most flourishing democracy, and for that to stay...
Let me help you in a different way. You would have seen the scheme of Indian penal code now coming in a different format. So it has a caption to read, no? As against whom the crime has been committed. That is the format of the British reward which is given to us. It speaks, this is a crime which is committed as against the property, reputation, state, no public health. No, as against whom this crime would have been? What you are possibly bringing it as a law? You are literally converting the Representation of People's Act to be a penal law.
Much obliged, Lordship. However, it is to be considered here that there is a problem of political instability that is very much prevalent in the country of India right now, and the collective responsibility of the citizens is to be put in place simply because of the...
We are suggesting there are other mechanisms wherein you can bring the voters for exercising their right.
Much obliged,
because you are enjoying a majority. Now, will it give a power to you to pass a law and then compel everybody to come to the polling station?
Much obliged, Lordship. However, the enforced mechanism here, or the mechanisms here that are being implied under Section 60B are absolutely constitutionally valid, simply because of the fact that these serve as deterrent. And talking about realism, an enforcement mechanism is very necessary here. It is the need of the hour, because there needs to be compliance with the legal obligation. Further, it is acting as a regulatory tool, this deterrent. Moving on. Talking about, again, the constitutional validation of the Section 62B, the Council for the Respondent would also like to cite the very foundational case law of Suresh Kumar Kaushal versus Nas Foundation. I'd like to draw the judge's attention to page number 25 of the compendium. In the same case, the judgment very clearly said that the state has an inherent interest in the constitutional morality, in the highlighted word here, constitutional morality of the people. The state's intervention in
interest in civic participation is reasonable, and reasonable penalties are being imposed for that exact same reason. Talking about duties, much obliged,
Lordship. However, the Council believes that the judgment talks about constitutional morality, and this is a case of constitutional morality as well.
The judgment says the state legitimate interest. Article 21A is imposing compulsory education, right?
Much obliged.
Now the amendment also compulsory to vote. There is no penal provisions in the section 20, in Article 21A. Now you are imposing penalize in Article 62B. There is a two mode of penalizing. One is the employment in the government job is a first one. Second one is confiscation of the passport. Both are directly violating section articles 19(1)G, article 41 and also article 21. Instead of imposing penalizing, now there is so many developments in the electronic medias. Instead of imposing penalty, my brother just says you can inventedly in any another alternative solutions you should give, like OTP system. Instead of that, why you are penalizing the people, our own people?
Much obliged, Lordship. Article 19(1).
Instead of threatening them, why can't they use that words enabling them or wooing
Even though so many NRIs are living in abroad the country, they also are very eager to put the vote.
Much obliged, Lordship. The very simple fact here is that there is a need for maximizing voter turnout, one, and that the enforcement mechanism here is valid because the question is about 62A mandatory voting. If not for an enforcement mechanism for the same, if it is simply about persuasion and through educational means, that simply wouldn't hold water because...
Counsel, let me put a very basic question.
Much obliged, Lordship.
You said no, nearly 70% of the population are exercising the vote now, only 30% is remaining. Do you have any idea who are the people who are not coming to the polling booth?
Much obliged, Lordship.
Do you have any idea? Did you make any survey?
Much obliged, Lordship. As a matter of fact, the amendment proposes certain exclusions as well.
No. I think I'm just interested to know the nature of the people who are not interested in exercising the vote. Or to go beyond that, those people who come to the polling booth and then exercise nota.
Much obliged,
Lordship. What are the people really?
Much obliged. The council believes these people are
really concerned with the electoral system. The scenario, the atmosphere wherein you are conducting the election, it really keeps them away. Let me put it in a very strong way. Those who are really public spirited, educated, and want a good governance, they are least interested in coming to the polling booth.
Much obliged, Lordship.
They are the people who are exercising the nota. Kindly remember, though you are an election body, you have not given any respect to the nota. It's only just protest, that's all. It doesn't have any validity. Now, assume, for example, nota is marking around 50%. Will you countermand?
Much obliged, Lordship. Your Lordship, the argument here is that electoral literacy, yes, of course, is the need of the hour, and to change that very aspect, to change that very... much obliged, Lordship. What the council for the respondent here is trying to say is that there needs to be a fostered democratic participation, and like you said, electoral literacy is very much the need of the hour.
Further adding on to the same, the council here believes that there should be a balance between rights and civic duties, which is clearly here. Upcalling the doctrine of harmonious construction, the council has a reason to also believe that...
Kindly see section 62A1 of the proposed amendment, or the amendment. All citizens eligible to vote shall vote compulsorily. Then why do you want to exempt certain categories of people or certain class of peoples? And what is the category of peoples? Who is to define the category of people or the class of people?
Much obliged, Lordship. There definitely needs to be an exemption clause here to exclude certain class of people because of the inability...
such an amendment.
Much obliged, Lordship, because there are certain genuine concerns and certain genuine exemptions here in this case, like that of a medical emergency or like that of, however, this hasn't clearly been defined yet, and we do so because this is just a hypothetical question later on.
The reasoning is that in spite of your amendment, in spite of making it compulsory, so you conceive yourself that there is no possibility of getting 100% percentage.
Much obliged, Lordship.
Now, is it right or not?
No, Your Lordship, the council believes...
No, by coming with an exemption clause, and allowing some people away from the electoral fray. Both. No, you yourself concede India is a country where 100% polling cannot be achieved. Is that right or not?
Much obliged, Your Lordship. That is not what the council here is inherently trying to imply, simply because of the fact that there needs to be some exemptions here, and like the bench rightly pointed out when the learned counsel of the petition was contending, it actually holds water here and is actually serving as a democratic, serving as constitutionally democratic, that certain exclusions are generally being concluded and excluded from this so as to upkeep democracy. So,
if you have anything substantiating, please conclude your arguments.
Much obliged.
We are running out of time.
Much obliged, Your Lordship. Further, this right, the right to vote, is not merely procedural, as it was held in Jyoti Basu versus Debbie Gosel case, and it was of fundamental essence to the very democratic system. Further, the council also has reasons to substantiate that this passes proportionality, and this is absolutely proportional. Because bringing into contention proportionality stricto sensu, proportionality in stricto sense, as it was endorsed by the case of Omkar versus Union of India, which gave a three-pronged proportionality test. One,
legitimate state aim and interest. There is a legitimate state aim and interest here, that is to maximize voter turnout. balance and neutrality. There is absolute balance here since exclusions are also being considered, and there is neutrality in this case because the Election Commission of India's position here is constitutionally validated, as the fact suggests. And Election Commission of India, like it says in 324, Article 324,
has been subjected to challenge. Probably I can argue on this point. You are not saying no, it has been applying.
Much obliged, Your Lordship. Election Commission of India has all the superintendents and in the widest power.
That's no valid point on your objection.
Much obliged, Lordship. And lastly, there is a rational and a reasonable nexus. That being said, the Council would like to move to the prayer. Much obliged, Lordship. Wherefore, in consideration of the facts presented, issues raised, argument advanced, and legal authority is invoked, it is humbly prayed before this august honorable court to dismiss this petition and or pass any other orders that this honorable Supreme Court deems fit in the interest of justice, equity, and good conscience. And for this, the respondent, as in duty bound, shall humbly pray. It was a pleasure arguing before this honorable court.
Cannot be substantially argued before the same court, Your Lordship, failing to prove the validity of the amendment of respondents, Your Lordship. And the doctrine of per incurium is the exception to judicial precedents. In what basis can the respondent state that the precedents in the case of PUCL and OPR, Your Lordship? And to your last rebuttal is that why the Union government remove the Chief Election Commissioner and appoint a new Chief Election Commissioner in 2003 before the 106th Historical Constitution Amendment in the 31st December of 2020. And what are the reason behind that who hold high number of MLA seats in the state legislature election? Indeed, Your Lordship. It was not so.
Yeah,